like treason, rebellion, sometimes banditry committed by rebels, revolutionaries, secret society members, right? And the stakes of these cases tend to be really high for both the offenders and for the state. They're really high for the states, both the Qing and the Republican state, because the border really presented hard limits to the reach of law to the state, right? Stakes were high for the fugitives, obviously, because these were in many cases capital offense cases, right? And the border also symbolized, I think, or demarcated key new legal spaces where rights were defined differently, where legal apparatus worked differently, right? And so we're looking at, for the most part, in the first few chapters of my book, the border between Canton and Hong Kong, where I think that the border really worked that way. It signifies intense vulnerability for the Qing state. Also, it presented opportunities and new legal spaces for the fugitives, where if you cross the border, then political rights get defined really drastically, right? And so thinking about how that geographical aspect of law played into legal history, played into really the history of the Chinese Revolution, more broadly conceived as both the Republican and later on the Communist Revolution. So the period that I look at is really between the end of the Taiping Rebellion in the 1860s to the early days, or the early years of the Nanjing Decade, and so from the 1860s to roughly the late 1920s or so. So I just wanted to talk a little bit of how I stumbled upon this project. Some years ago, I transcribed and published the archival documents written by these are Qing diplomats, Qing ministers stationed in London. And most of these were in the FO17 files. And I was stunned by the richness and the legal persuasion of some of these letters. And many of these people, I think, were quite familiar with, for instance, the famous Marquis Zheng, right? Xu Fucheng. And one of the cases I looked at was under Luo Fenglu. Right. So, and then I followed these cases and I saw that extradition, especially extradition of some of these politically threatening cases, were really a key function of the Qing's overseas office. They dealt with negotiations of many of these very high-profile cases, right? And so if we were to map out the different kinds of offices that are involved, I think that most of the cases that I looked at dealt with three sets of offices. We have Qing officials in the local metropolitan, and that's Beijing, and the overseas offices, right? This is really a drastically simplified version of some of these offices that I looked at. And then we have the British Foreign Office, Foreign Service, and then we have the colonial arm, right? And so one type of interaction that I looked at was really what I really think of as local interactions, right? This type of interaction often involved applications of treaties and law on specific cases, right? As local officials, that's the Qing Governor General and British Council as the intermediary between the Qing and the Hong Kong governor. They negotiated between the different laws of the British colony and the Chinese provinces. And so it really is a legal history from this point of view, right? And I think that it also has a diplomatic component to this project because many of these diplomats were also involved in deliberating, perhaps not on specific cases, but on larger the rules governing transporter fugitives, right? And these rules were negotiated, amended, and signed into treaties. And these discussions often involved larger political or geopolitical and diplomatic factors, right? And so this project is also a diplomatic history right? But then we're also looking, in some cases, at intra-bureaucratic interactions, both within the Qing and the British governments. And what we see from this point of view is really a lot of tension, not between the Chinese and the British, but I think within the bureaucracy, right? For instance, I think that the Qing provincial officials had very different priorities from the Zhongliyan, and the same thing, for the British, the Foreign Service really cared about a very different set of things from the colonial offices, right? So that's the three different dimensions of this project. On the other hand, if I may, this is also a project with, I think, keen contemporary relevance as well. When I started this project, the Edward Snowden case was still unfolding. I don't know if people remember that case, right? And at one point, the CIA director suggested that Russia should extradite Snowden as a gift to the then President-elect Donald Trump. Right, and that really made a big impression when I was working on this. And it really also resonated with some of the cases that I was looking at, where the extradition or the handover of politically sensitive cases were being considered as bargaining chips, right? And then there was the Julian Assange case, which I think also raises the question about the definition of political crimes, right? And obviously there was the Hong Kong protest against the extradition law with China that's very much back in my mind. And that case, I think, really highlighted China's intense sense of vulnerability when it comes to its lack of legal instruments to bring back fugitives from Hong Kong. And what I find is that many of these cases were not recent at all. They actually had deeper historical roots, right? And so this is my attempt at trying to see echoes of these historically, right? And so that's the motivation and the scope of the project. Next up, I'd like to just talk about a few, I think, interesting conceptual questions, right? Because I used some really big terms in the title, right? First of all, I find the concept of political crimes to be uniquely interesting because obviously it's not a native term in Chinese history, right? Some historians would argue that it corresponds to roughly the first 3 of the 10 great abominations, right? Treason, rebellion, insurrection. And Philip Hume, in his famous Soul Stealers, applied the term political crimes to, and I quote, sedition in all its various guises, whether religious heterodoxy, literary innuendo, or outright revolt. He then defined these crimes as acts of transgression against the values of institutional foundations of the polity, activities which attack the legitimacy of the imperial system and challenge the cosmological foundation of its sovereignty, right? And then Joanna Wady Cohen added that sometimes collective responsibility is a more predictable indicator for which crimes were considered political. And what I found somewhat unsurprisingly was that in both China and Europe, punishments for political crimes were similarly harsh, arbitrary, public, and quite visceral up until the turn of the 19th century. It's very late. And states often signed agreements for the mutual delivery of rebels, regicides, and other kinds of what we might consider as political offenders, right? And punishments of these crimes followed a very similar kind of principle. And I think Foucault puts it really nicely, right? And he says the very excess of the violence employed is one of the elements of its glory. The fact that the guilty man should moan and cry out under the blows is not a shameful side effect. It is the very ceremonial of justice being expressed in all its force, right? So there was a divergence. Indeed, there was a divergence somewhere around the turn of the 19th century roughly, after the French Revolution, where punishments became more about disciplining the body and transforming the mind, and the presence of law, I think, became more pervasive, became more precise, and more hidden in some cases, right? And so that's the transformation of the punishments of political crimes in Europe, right? And it's really only 100 years later that we see a similar kind of transformation in Chinese history, roughly around the turn of the 20th century. The treatment of political crimes became more lenient. It's no longer 10 abominations, something that's unthinkable, right? It became first by the Japanese concept of the 破库忌韩, the 博士犯, right? Which was actually used by a lot of Qing legal reformers, although the term was never officially introduced into Chinese discourse, right? But then around the 1920s, we see it morphed into the concept of the 政治犯, of the political offenders, right? And so one of the things that I try to look at in the book is how this transformation is not just a matter of top-down legal reform of lawyers and these jurists are arguing what to do. It's also complicated by the very real struggle of the Chinese states to pursue and to recover these transporter fugitives. And there are actually volumes of discourse and dispatches that emerged out of these painful experiences, right? And so that's the first set of somewhat theoretical concepts that I was trying to look at, is the evolving concept of, political crime, for lack of a better word, right? Another kind of dimension that I tried to take in attacking this project is the legal framework for understanding the jurisdiction of interstate transborder fugitives. And one of the things that I argue is that there was a real shift from a model of personal jurisdiction to something that's more based on the territory, right? We call it territorial jurisdiction or territorial sovereignty. And one way of thinking about it is, if we were to list all of the treaties that the Qing signed with foreign powers, which included some kind of treaty provision, a clause or two clauses on fugitive delivery, then we see there are roughly 24 of these from the 1700s to the fall of the Qing in 1911, right? In each of these cases, agreements were made, and I argue, really based on the concept of personal jurisdiction, right? And so if we zoom into this group signed with the Russian Empire, when we see that in the language of many of these clauses, had to do with, things like this: henceforth, fugitives shall not be concealed by either side. They must be vigilantly pursued and apprehended, then handed over to the authorities stationed at the respective border, right? And so that presumes that the law of the home country does not stop at the border. The other side actually had the responsibility of arresting and delivery of these fugitives back to the home state, right? Actually looked at all of these types of borders, and roughly they all follow this principle, right? And if we look at the treaties with the British, it's also based on the principle of personal jurisdiction. Each of them basically says that British subjects should be apprehended and delivered to the nearest British consul, right? Whereas Chinese subjects taking refuge in Hong Kong or aboard foreign ships or in foreign houses should be delivered up by the British officials to the nearest Chinese authority, right? And so in all of these cases, including foreign subjects, I mean, this is one way of thinking about it, right? And so in cases involving foreign subjects from states which established consular jurisdiction, then extraterritoriality, which is a concept that everyone is familiar with, is the principle that governs foreign subjects in China, right? It basically says that Chinese authorities are bound to deliver foreign subjects to the nearest consul or foreign authority, no questions asked, right? It's really a procedural transfer, right? On the other hand, Chinese subjects, right, in foreign settlements, ships, and houses must be arrested and delivered to Chinese authorities, right? This is not extradition, or sorry, this is not extraterritoriality, obviously, but this is, something that I call fugitive rendition, which I think the Qing understood as a reciprocal act to extraterritoriality, right? And then the question is this system that we're looking at sort of this reciprocal obligation between the Qing and foreign states to arrest and deliver the other fugitives of the other nationality? Is this extradition, right? And I don't think it's not. I don't think it is the same as extradition, because this is based on the principle of personal jurisdiction and a sense of legal pluralism, right? The idea that there can be multiple legal systems coexisting in the same space, governing people according to different principles, right? And if we look at the language of the treaties with the British Empire, right, and we can see that the British government only recognized this type of thing as extradition only in cases when fugitives cross sovereign boundaries, such as in the Burma Frontier and Trade Convention, signed in 1894, or in the Convention for the Extension of Hong Kong. This is where we see the word extradition. The tricky fact is, when Hong Kong was first ceded, it was in fact not really considered as fully sovereign, which is something that Ivan Lee at NUS also studies from the British point of view. It was understood as, what Ivan calls this inchoate kind of territory, where Chinese subjects were ruled under Chinese laws and therefore should be surrendered to the nearby Chinese authorities, right? And this is why the procedure is not known as extradition. If you look at the language here, it's fugitive rendition. These fugitives should be delivered up, right? It's not the same concept, right? And so one thread of this somewhat conceptual question is, how did this system of fugitive rendition based on the principle of reciprocity change when the British start to treat Hong Kong as sovereign? And to some extent, foreign settlements were considered as sovereign territories as well, which means that accommodating Chinese law in these territories became seen as compromising British sovereignty, right? And so if we were to really think about the change here, then what this means is that the British and the Qing officials then started to recognize two different kinds of frameworks for governing fugitives, right? Foreign fugitives were delivered up as a matter of procedural transfer, right, from the Chinese authorities to foreign consuls. But Chinese fugitives in foreign settlements or ships and houses and so on were only surrendered to the Chinese authorities if the conditions for extradition were met, right? And so there are a whole set of legal standards governing what those conditions were. And these conditions were based on modern concept of extradition, including dual criminality, which says that the alleged offense must be a crime in both the requesting and the requested state. It has to meet a certain threshold of severity. It has to meet certain evidentiary standards to the satisfaction of the judge of the requested state. And most importantly, there is the political offense exception, which means that political crimes are excluded from extradition, right? So, and it becomes not a reciprocal kind of thing. It really is governed by two kinds of processes. One is administrative and the other one is legal, right? Unfortunately, none of these developments, none of these conditions were really understood or foreseen by either the British or the Chinese government when the treaties were originally signed in the 1840s. and then in the 1850s, right? And this, I think, is because it was only after the mid-19th century that the concept of extradition treaties as a diplomatic tool among Western states began to take shape, starting with the Anglo-American Webster-Ashburton Treaty of 1842. And these treaties were really a response to a real change in the ease of transportation by the fugitives, right? With steam transport, making it much easier for fugitives to go across borders fast, sometimes anonymously, sometimes carrying large amounts of money, especially financial crimes were very troublesome to some of these states, right? And so these agreements that are based on extradition principles were, in fact, I think, meant to streamline, make it faster, make it more efficient for extradition to go through, and to make it more integrated with the domestic judicial system, right? And I think that the interesting and somewhat ironic fact is that whereas the modern extradition system was intended to make fugitive delivery more expedient among nations with comparable political and legal systems, it simultaneously made it almost impossible for Western nations to abide by their original treaty obligations with China. Right? And so, of course, both sides understood this change and neither quite liked it. They approached each other and they tried to negotiate a few times something that's more comprehensive, something that can be called an extradition treaty to replace this more 19th century kind of fugitive rendition agreements. But they persistently ran into the problem of this imbalance of relationship, right? Because under extraterritoriality, Western consuls already govern or have jurisdiction over their nationals in China. There would be nothing to gain from that point of view by signing an extradition treaty with China. It only mean creating a one-way obligation of enabling the Chinese government to recover their fugitives, right? And this is another motivation for the Republican state to abolish extraterritoriality, is so that they could sign proper extradition treaties to bring back fugitives, right? I find this quote to be really striking. This is from F.E. Hinckley, District Attorney of the United States Court for China. He says, the reason China has no general treaties of extradition is that in granting extraterritoriality, she has engaged not to assert jurisdiction over the citizens or subjects of the treaty powers within her territories, right? And so as long as extraterritoriality exists, it would be very difficult for some of these Western states to justify entering into a new extradition relationship with China, right? And so that's another aspect of this project. Next up, I'll quickly go over, and I know the discussion has been somewhat dry and abstract. I'll go into a couple of case studies to look at how these practices changed over time, right? The first case takes us back to the aftermath of the Taiping Rebellion. One of the lieutenants of the Taiping force opened up a shop in Hong Kong and used it as a front for supplying arms to the remnant troops of the Taiping in the Canton region. He was identified by the Qing informants. He was charged with piracy by the Governor General of Liangguang, and he was extradited in 1865 after two brief hearings at the police court, based on which the magistrate found probable cause. And he was delivered to the Chinese authorities by the acting governor, William Mercer, and soon after was executed by the painful method of death by 1,000 cuts, right? And of course, a few weeks later, the press started identifying him as the famous Mo Wang, a major leader of the Taiping Rebellion, which turned out to be a false identification. I think they were doing it to get more attention to this case, but he's in fact not the Mo Wang. And based on that dramatic press coverage, a member of the parliament wrote a very harshly worded letter to the Foreign Office and said that British officials should be held accountable for the gruesome death of this innocent man. And I try to reconstruct the case to show how it was handled by officials on the ground, and then how it was interpreted by those at the metropolitan areas in the center, right? And so let's first look at how the authorities in Canton dealt with the case. According to Article 21 of the Treaty of Tianjin and Hong Kong Ordinance Number 2 of 1850, the proper legal procedure for extradition can be, I think, summarized as follows. The Canton Authority, in this case, the Governor General Liang Guang, should first of all send their extradition request to the British consul, whose approval and representation of the case is required for forwarding it to the governor of Hong Kong, who then causes the magistrate to issue warrants and undertakes investigations. And if there is probable cause, the prisoner will be detained until further orders from the governor. And this is an important point. I think that by and large, before the 1860s, fugitives were given up on demand for crimes against Chinese law, according to Ordinance Number 2 of 1850. It really is the basis of judging whether an act is really an extraditable offense. Is Chinese law. And then what happened is that this is really around the type of the mop-up campaigns against the last of the Taiping Rebellion, and the brutality of these campaigns and the treatment of the Taiping prisoners increasingly, I think, made the Hong Kong government reluctant to send back many of the rebels or rebels disguised as pirates. And in, I think, 1863 or 1864, the Canton, one case was denied because of insufficient proof of guilt. And in the Hou Yutian case, which happened after that, the Canton officials, in this case, Governor General of Liangguang, Wei Lin, and then underneath him, the guy that I like a lot, Guo Songtao, they consulted Consul Robertson, and was actually given the advice of strictly concealing the political nature of the extradition request, right? And to keep the case strictly as piracy alone, right? And then he very cleverly sort of just abstained from forwarding or representing the Qing government in this case, and sent the letter to Mercer, right? Of course, after the scandal was reported by the press, the Foreign Office was in a bind because both Governor Mercer and the consul, Robertson's case, insisted that they did not know that Ho was a rebel. And the British experts in Chinese law, in this case, Thomas Wade, insisted that their understanding of piracy is that it can be potentially punishable by the lynch method or death by a thousand cuts, even though the Qing's code states it to the contrary, right? And so the core of the problem is that the punishment of Hou Yutian essentially conflated the lynch that's meted out to a rebel leader with the punishment of pirates. And it really caught Foreign Office in a difficult conundrum, because which one is it, right? There's not enough information for them to really know. If Ho's status as a Taiping rebel was confirmed and made public, first of all, it would mean a scandal. It would also mean that under existing agreements, political offenders could be extradited, and that's not good. That has to be fixed, right? On the other hand, if his crime was indeed piracy, there's an even bigger problem, because there's so many pirates that are rounded up and had been sent back, right? And at the time, I think the British Navy was assisting the Chinese government in rounding up pirates and sending them or deporting them back to China, right? And so you can't do that, because if they're all going to be sliced to death, right? According to the cruel Chinese law in the imagination of the Foreign Office, that wouldn't be humane, right? And so the solution was reached when Alcock, the British minister to the Qing, negotiated with the Zhonglianmen on changes to the implementation of Article 21 of the Treaty of Tianjin. And so just to remind us, this is how the original system worked, right? This is the sort of the direction of the paperwork, and we've seen this, right? And so what the changes were effectively was that now the provincial authorities must provide a no torture guarantee to the British Council, and the Council must be satisfied that the prisoner would not be subject to punishment for a different crime, for a different charge, or be tortured at any stage. And internally, British officials agreed among themselves that no political criminals or political offenders would be extradited, and no extradition could be granted, which would not be considered a crime in British law. But this was not communicated to the Qing government. So there's a sort of an unwritten script, right? We are not going to be sending back criminals which we don't consider to have offended the law under British law. But we're not going to tell the Qing, because if we tell them, then it gives them the excuse to request modification to the Treaty of Nanjing for things that they find inconvenient, right? And we know that there were numerous things that the Qing were unhappy about with the treaty, right? The understanding is that that would jeopardize the legal basis of that treaty, right? And so that was sort of how things were by the 1860s. And the aftermath is also interesting because there appear to be substantial differences between the Chinese and the British understanding of the so-called no torture guarantee. If you look at the letters of pledge written by the Governor General of Liangguang, he agreed not to use torture in excess of the law. He did not unilaterally and just unconditionally promise not to use torture, whereas the British officials thought that the promise that they had secured was no use of torture whatsoever, right? And so there are actually two different standards. The case also lived on in public memory in subsequent handling of extradition requests. British diplomats and colonial officials, I think, used the so-called the Mo Wang case to demonstrate the barbarity of Chinese law, since it was never clear who the guy really was, why he was demanded, and why, if he were a pirate, he would be subject to the Ning Chun method. All of these uncertainties were ultimately attributed, I think, to the inscrutability and the kind of a mystery of Chinese legal system, right? And so instead of settling the question, the conclusion of the Mo Wang case was merely, I think, the beginning of a long series of decade-long misunderstanding and attempts at making fixes which didn't really fix the problem, but then initiated more problems, right? So that's the first case. And this system operated for about 20 years or so until the mid-1880s. And there were persistent debates and controversies, of course. And in the book, I wrote about it, half a dozen cases. But the highlight and the turning point was a 3-4 year legal battle fought between the Qing legation in London on the so-called the case of the 13 Cantonese who was charged with killing 3 of their distant relatives and fled to Hong Kong, where they were arrested. And this case was important because the 3 distant relatives happened to be 3 generations, right? And so the grandson, you have the father, and then you have and the grandfather. And according to the 10 abominations, that is a very severe crime, potentially punishable by the lynching method, right? And so in this case, the paperwork flowed as usual. The Governor General applied to the British Consul in Canton to forward a request. But there's a hiccup in this process because the British Consul, newly appointed, objected to the extradition request, citing rumors that previous undertakings, previous cases, had been violated by the Governor General. That there was actually a similar case of extradition of 13, happened to be in a different clan. And there were rumors that were circulating that the 13 had been tortured and many of them were sliced to death. And so he actually objected to the extradition request, right? And then after some back and forth of diplomatic work, the case was forwarded or issued, the Zhongli issued an injunction to the Minister of London, Minister Zheng Jizhe, who then entered into direct negotiation with the foreign minister, and to Zheng and to, I think, most of the Chinese officials, the case was very important because it was so high profile. Numerous witnesses had been detained and rounded up and were waiting for trial. And everybody knew about it. And I think that there was the expectation that the outcome of the case would determine the future of extradition, right? And so he pressed, he urged the Foreign Office to fulfill its treaty obligation. And these demands prompted debates within the British government. And I think at one point, the Foreign Office ended up agreeing with Zheng Jizhe's position and instructed the Hong Kong government to arrest and deliver the fugitives, right? But then the Supreme Court of Hong Kong, citing technical errors in how the case was handled, actually ended up releasing the prisoners on a writ of habeas corpus. This was at the end of 1881, right? And then there were more arguments between the chief minister in London and the Foreign Office that lasted a couple years, and during which time the fugitives had joined the Catholic Church while they were in Canton. They gained the bishop's support. They gained the press's support. They had their own lawyers. And there were articles that were published in newspapers framing their case as an anti-Christian persecution by their powerful clans back in Canton, right? Critically, supporters of the 13 framed their crimes as political offense on the basis of their religion, and argued that they should be offered protection. But if we look into it, there was no indication that they had been Christians prior to their arrival in Canton. It was more of an interlineage feud over gambling and distribution of property, right? But then it was framed as a political offense, right? And so the Hong Kong government then released the 11 of the prisoners. The other 2 had been discharged earlier. And the basis of that decision differed from the previous decision to release the prisoners. This time, it's no longer, if we release them, or if we deliver them, they would be tortured. And this time they really used the political offense exception to justify why they should not deliver these fugitives. So I think another side of the story is that it shows how this jurisdictional boundary between Canton and Hong Kong really offered an alternative arena of legal empowerment, right? We see that fugitives themselves understood the differences between the colonial laws and the laws of Canton. They themselves were seeking out lawyers, right? And they understood that it was a significant colonial reservation about returning them to Qing jurisdiction. And for instance, those who were charged with severe crimes punishable by death would steadfastly deny their charges in the hope of avoiding a conviction. And as we know, as Qing legal historians, if there's no conviction, if there's no confession, then the magistrate really cannot convict you in a Qing court, right? And so turning the Canton government's no torture guarantee to their own legal advantage, right? And then we also see that defendants with the means, with financial means, hired lawyers, which then necessitated the Qing government to also hire lawyers, right? And so by the 1880s, the Qing governor general were spending thousands of what they consider as taels of silver on hiring lawyers. And it was something that's very difficult for them. You also see that legal knowledge spread not just between individuals, but between these kinship organizations, as shown by the fact that two separate groups of kins escaped as a group of 13 in consecutive years, right? 1882, 1881, and 1882, right? And in my book, one of the things I try to show is how the border regions were, people along these border regions were really quite resourceful. And in these cases, especially the case of the 13, prompted the Hong Kong government to pass the Chinese extradition ordinance of 1889, which really, in many ways, enshrined the political offense exception. We see that we're kind of out of time. I'll try to wrap up very quickly here, right? Just one more case that has to do with this, right? Some of the most important cases that I tried to look at involved rebels who didn't passively use the concept, but proactively engaged with the concept of political offense exception to frame their crime as political offense, right? For instance, Sun Yat-sen and his earliest secret society associates, when he was arrested or when he was detained in London, he published a book that framed his crimes very much in line with the prevailing definition of political crimes in the West, called his organization a Young China Party, who's seeking a peaceful reformation, whose objects were so wise, so modest, and so hopeful, right? Sun Yat-sen, I think of him as the furthest thing, as from being a modest person, and wanted to overthrow the Qing in as quiet a way as possible, at any rate, without bloodshed, right? And I think all of this later on in the 19-teens, or even before that, in the last few years of the Qing, really exerted a huge influence in the mobility of the opposition of the Chinese state, as Liang Qichao observed in 1905. And he said, even before, and he's talking about the political oppositions, right, the revolutionaries, he said, even before they start expressing their views, they have a foreign place or a treaty port as a place of refuge in mind, as a place of asylum, right? If they hear any noise, they spend a few dollars, travel a few days, and seek safety in Shanghai, or for those with means in Hong Kong, Southeast Asia, or Japan. Given the existence of this convenience of refuge, how could China produce thoughtful and brave activists such as those in the Meiji Restoration, right? And so he's actually saying that the existence of extraterritoriality and the sort of the curious spatial arrangement of colonial spaces actually undermine the integrity of the revolutionary movements, right? Okay, just to wrap up, what I do, what I try to do in this project is, I only talked about a couple of these people, but I think it really applies to many rebels and revolutionaries in this period. And what I try to do is, I think, hopefully not to fill a gap of our existing knowledge, but rather to offer a different kind of backdrop to understanding many of these familiar figures and activities of the late Qing and the early Republican period, right? What happens, for instance, when we think of the Qing legation's kidnap of Sun Yat-sen in London, through the broader lens of shifting extradition laws and the emerging efforts by nation states everywhere to pursue transnational criminals at the turn of the century. What they were doing is very much in line with the international usage, doing extraterritorial abduction and extralegal detention and things like that. It was not that extraordinary for the Qing to have done that. How might, for instance, 100-Day Reform, people like Kang Youwei or Liang Qichao, how does that look differently when we consider these in the light of growing cross-border mobility of political offenders? Because many of the survivors among the leaders of 100-Day Reform, they became exiles, and they did have to wrestle with this question of the laws bring back them, or which would potentially bring them back to China, right? And so one way of thinking about these people is really three sets of in-betweenness, right? Many of them were really in between domestic and international law, in between treaties and municipal regulations, and in between justice and diplomacy, right? So in conclusion, very quickly, number one, I think we should perhaps pay a bit more attention to the mobility of political fugitives and their interactions with legal systems when we try to understand the late Qing and the early Republic. And the modern concept of the 政治犯, I think, originated in these debates of cross-border fugitivity and extradition. And I think that they cannot be solely understood from a perspective of state versus society, which is a domestic point of view. The existing literature on political crimes have been exclusively on domestic relationship between the state and the society. I think that there is a transborder and international dimension to that as well, right? And I think what it shows is that intense sense of vulnerability felt by the Qing and the Republican states when it comes to border crossing fugitivity. And as I show in the book, I think that this sense of vulnerability is key in understanding the tendency towards absolute territorialization of law by the Chinese state in the latter half of the 20th century. And finally, I think that there is a legal dimension to the Chinese Revolution as well. I think the perspective that's often taken is how revolution changed law or changed the concept of law. But I think that the opposite is true as well, that international law and many of these rules actually affected the shape and the mobility of the Chinese Revolution as well. So that's my presentation today. Please make comments, raise questions. Thank you so much for your time.
This wonderful introduction to your book. So we have some time for questions now. If you're here with us, please just raise your hand and ask a question. If you are with us online, please submit the question through the Q&A button, and I'll read them out for today to respond to. So, do we have any questions or comments?
Or critique.
That's fine too. Oh, Michael, please.
Thanks, Jenny, for fascinating introduction to the book. I very much look forward to reading it. Quick questions. There's a number of roles played by different parties within China, Hong Kong, or Britain. But there's one role which sometimes could be critical, which is the role of the court, especially Supreme Court in Hong Kong. So have you seen any materials showing how British councils in Canton or colonial government, how did they deal with those judges and court's judgments, sometimes judging the case against their interest?
No, I haven't. That's a good question. That's something that maybe I should have looked into. I think a lot of these cases did not really reach the Supreme Court. I think they were mostly handled by the diplomats, by the governor. I think that the role of the court, Chris might know more about this, mostly I think had to do with, sort of letting them off because of legal irregularities in the way that they were arrested in the first place. That's the extent to which I was aware that the Supreme Court was involved in these cases. I think it was mostly dealt by, low-level bureaucrats and diplomats.
So can I have one very, very quick follow-up?
Yeah.
Is that, say, for example, letting them off, if the British consuls in Canton actually proposed not to let them off and send them back to Canton to Qing authority, so the judgment is not in their favor. So have you seen any materials showing the reactions of the British government, the colonial government, facing with the judgment not in their favor by letting those fugitives off, rather than sending them back to China and solve the problem?
Right. So I think that I think there's a question of, what do we mean by being in their favor, right? And I think that the British consuls, depending on their relationship with the Canton government, some of them had a really good relationship, like Robertson guy, and just great relationship, really cozy, right? He's very eager to please the Canton government, right? But after he retired, there's another one, forgot his name. He was much younger, he was much more professional, right? And didn't really have that kind of working relationship with the Canton government. And then very much was about applying British law in the cases that he handled, right? And I do think that the 1880s is a very big period of change from the cooperative policy of the 1860s and 1870s, shifting towards a more, I think, aggressive or more tension between the British and the Chinese, and we see that as well, right? And I think that the Foreign Office in many cases were not so informed with law. In a lot of these cases, they sided with the consul in trying to please the Chinese government because of ongoing diplomatic negotiations.
Thank you. I really enjoyed the paper. I have sort of two questions. One, a long time ago, I looked at some extradition sort of battles between Nepal and the British India in the 1850s. And I remember after a while, the Nepalese government just says it's not being reciprocated, so we're going to stop sending rebels back to British India, right? And so I was thinking, but I was wondering how much were the Qing aware of treaties being signed with other Asian states, and were they looking at that and learning from those experiences, or did they have sort of relatively little understanding about the fact that there were treaties signed with, say, Nepal, or I don't know if other Asian states? Was there a sort of a sense that they could sort of use those experiences to shape how they were going to then respond to these treaties?
Yeah, I think it's something that we could take a look at with on this particular slide, where I enlisted all of the treaty clauses. Way back, right? So what I see is that most of these, with these European states, really followed the Treaty of Tianjin in 1858. I mean, largely very similar language, right? And then after the change that I described in, the mid 1860s, where the political offense exception was being, sneaked into the implementation, some of these later treaties that are signed, right, especially with Japan and with Portugal, you really see that the Qing is unambiguously trying to assert that Chinese fugitives must be delivered back. I mean, there are language that says that no matter what the crimes, may be, these are the obligations, they must be arrested and delivered. And so what you see is that officials kind of learned from that Canton experience, shaped how they approached some of these later treaties, right? And another change is after the Sino-Japanese War of 1895, right? What you see is that Japan then joined the league of many of these European states of removing the reciprocal fugitive rendition clause, which they had entered into with the Qing in 1871. If you read this, then it's basically, it's, you know, very much based on the principle of personal jurisdiction. So that treaty basically said that if a Chinese offender breaks law in China and escapes to Japan, he's not going to be, or she is not going to be delivered to the Chinese consul. So they removed that. And so Chinese government no longer enjoyed extraterritoriality within Japan, right? And so that's another change. A third kind of change, which is not reflected in these, is really the land loss of the treaty ports, right? Where, you know, after the 1890s or so, what you see is that this extradition sets of rules came to be adopted by the treaty port authorities, where if you have a political case committed by the Chinese in, say, foreign settlement in Shanghai, it goes to court. It has to be heard by the foreign assessor, and the extradition laws then apply as well, right? And so in many cases, you see that the treaty ports then copied the Canton case. Yeah. I don't know if that answered your question.
That's great. Yeah. I think one other quick question. Alongside the extradition, the legalistic route, did you see any evidence of, I presume, the British, maybe more than the Qing, having any kind of like sort of discussions about assassinations, being like, we can't get them back as sort of, you know, an assassination of the sort of sending people in to sort of knock them off outside of the law? Was there any sort of evidence of that happening with
Is
these,
it Qing?
or the British into the Qing, or the Qing into the British with people they wanted to get back? Because actually the legal route is always like tricky and long, and it can be. Was there any sort of sense that you know, nowadays people are often, sort of a terrorist will often be knocked off by someone, right? And no one knows.
And they did. In fact, I think that Chris's new book deals with some of these cases. And there's one particular case, I think in 1903, of Yang Kui-wan, right, where, you know, the Qing is going around by just killing the guy in Hong Kong, right? And in fact, I think that they try to do things like luring them onto a boat somewhere on the border and then packing them up. And I think that what that did, you know, I try to be sympathetic to the Qing, right? And one of the things that they try to do is they did try to go through the legal channels, and those were blocked, right? And so then they resorted to these extra legal means of abduction or luring or assassination in some extreme cases. I think because some of these legal channels didn't really work. The same thing with Sun Yat-sen in 1896, right? And the Qing had a whole discussion about how to extradite him from the United States, from Japan, from London. And at one point, they were looking at this treaty, I think with Burma, saying, oh, we had just handed a Burmese terrorist back, you know, from the Chinese territory to the British authority in Burma, who was causing so much trouble. Why don't you do that as a reciprocal act and hand Sun Yat-sen back to us from London? Obviously, the answer is that it only applies to Burma. It doesn't really apply elsewhere, right? And they really didn't understand that. Right? And so from the point of view, I think from the Qing and including the British Secretary of Legation, Helena McCartney, the Qing had every right to do what they did, because they were reading the law very closely, and they thought that, you know, by treaty, they did have the right to do that.
Jenny, thank you. That was fascinating. And I really like the diagrams. They help explain things a lot. And following on from Michael's question and your response, I think from my reading, yes, the Supreme Court didn't come in very often, and the real work was done at the magistrates level. And the difficulty there was that magistrates were not legally trained and would often come up with decisions or recommendations that were contrary to even to their own gut feelings, just to get rid of the cases. And this was a complaint made by governors, particularly in the 1880s. The other difficulty for magistrates was that lawyers would often come in on both sides. The Chinese government was employing lawyers at great cost, and the defendants or the fugitives, if they could afford it, were doing the same. And this made proceedings very lengthy and very complicated. So I think you did say that that very interesting diagram early on in your talk was a simplification, even though it's actually quite complicated. But I guess you could go into every box and there would be other personalities, other institutions, wheels within wheels, and tensions, even within a small place like Hong Kong, where governors were very impatient with the magistrates, especially when they often took so long to deal with cases. And similarly, the lawyers in Hong Kong were making a lot of money out of it.
Right.
And the judges were reluctant to get involved at an early stage, even though they were at one point required to, because they didn't want to preempt any later habeas corpus actions. But anyway, that's just a comment.
Yeah.
But my question is, and it might be a tricky one, is there any quantification of the number of extradition requests, both for political fugitives of the kind that you've been discussing, but also for ordinary common criminals, robbers? Piracy, there is some material, I think, in the early days, but robbers, murderers, and so on. Have you come across anything in any of the archives on actual figures?
So I was at the National Archives in London, and that was one thing that I was actually trying to look into. And there were these cases and these booklets that had numbers. Unfortunately, I did not see the categories of these crimes that I was looking at. So that's something that I think that awaits to be done still, and that's a regret of the book, that I didn't really get the numbers, right? And on some level, you know, one of the things I'm trying to show is that this is a type of legal case that, you know, it's probably, you don't see a lot of them, but it's not driven by the number of cases. It really is driven by the particular nature of each of the cases, because each case is a precedent, right? You don't really need more than one case to really change the course of the application of the law, right? Yeah, but that's a good question. Yeah.
Fascinating talk, waiting for the book. Can't wait to see it in print. The schemas, the diagrams that you referred to earlier, that's really helpful. The book and your talk focus, you focus on more of the interstate dimension of this transfer, the extradition. You're talking about two big empires. Do you feel that, or do you think that the within the empires, there is less of a gradient in ways that there's a different level of either the different laws or different there's differential in ways laws are being administered and enforced that would create any need for fugitives or alleged criminals to be transferred from one jurisdiction to another, either within the Qing Empire or in the British Empire? And are there such cases that would have informed the way they formulated the treaties, especially the extradition clause?
It's a good question. Yeah, something that I didn't really think about. One thing that I did look into is I compare the interprovincial fugitive rendition procedure within the Qing Empire to these treaties with foreign states. What I find is it's very similar. It's the same set of language, same set of laws, same kinds of punishments for officials who fail to make arrests and to fail make deliveries, right? And so one of the things I concluded roughly was that these, when they signed these, and especially the set, right, language that's like this, it's very similar to say, you know, if you read the Qing bureaucratic code that governed, and so, you know, inter-provincial rendition, same language, right? And in many of the cases, the emperor would say, it doesn't really matter if you get the guy right, you know, don't worry about the identity, just intimidate, you know, and to bring things to a resolution as fast as possible, right? And so the British, I think, were very careful in making sure that the identity of the person who's demanded is exactly who the, you know, who the Qing said he was, right? But I think that from the Qing's point of view, if a crime is committed, especially something that's as grave as the murder of the three, what they want is to show the local population that consequences are being meted out, right? And so in some cases, they would actually find, you know, junior members of the kin organization and have them replace these fugitives and punish them instead, right? But anyway, that's on tangent.
Same dynamics in the more maritime British Empire of non-contiguous
Yeah.
territories, except through maritime connections.
Could you clarify that?
So I'm trying to see if there are different there's a different mechanism for the British Empire versus Qing Empire. Within the Qing Empire, you have all these provinces, different jurisdictions that are linked through
That's right.
land-bound
That's
topography.
right. Yeah, I think so. The Fugitive Offender Act, right, in 1881 or 1882, basically says that the administrative demand is sufficient to transfer fugitives between the Commonwealth denominations. It doesn't have to go to court, right? I think it's very similar that these are dealt with swiftly by bureaucrats to solve practical concerns.
Right. I guess my question is whether there's a perception of differential.
Oh.
This is a more lenient jurisdiction. That is more stringent jurisdiction. There's a gradient. So we feel that there is.
That.
Yeah.
I think so. Absolutely. In each of these cases, what I discuss in the chapter is how in the wake of these cases, what you see is really a wave of people who try to do similar things, right? For instance, after the case of the 13, you really see the perception by the colonial officials. They're being inundated with similar cases. Unfortunately, I can't really look at evidence from the point of view of these fugitives because few of them actually left records, but you can see it from the anxiety of the colonial officials, right? And you look at the timing after Sun Yat-sen was let off in London, then many of the secret societies then used his name, saying that I'm affiliated with Sun Yat-sen, right? It doesn't matter that they come in to loot or to cause trouble or to attack the British in some cases, as long as they're affiliated with Sun Yat-sen, well, they're political offenders, right? So I think that there is that perception.
Well, let's follow up afterwards and
Yeah.
I'll learn more from it. Can you go back to the slide with all the treaties?
Yeah.
Now, this is an emerging international landscape of states signing treaties with one another, assuming that everyone is on equal footing, right? But that was just emerging at the time. My bigger question is, you're creating all these spaces that are supposed to interact with one another, but fugitives usually go to the crevices.
Yes.
So this does not populate the entire world and not even the region. So I would imagine, with this type of topography that is emerging geopolitically, fugitives will then go to Indochina, right? You are covering Japan, Korea, but then there are other places. So do you feel that in terms of the proliferation of such treaties, other zones emerged where people would start to float
They start
about?
to float into spaces where there is no extradition treaty. That's why they hire lawyers, because lawyers can tell them, well, actually, there is a treaty that was just signed. There's no treaty, right? But then I think what's interesting about the political offenders is that if they're interested in further, continuing their revolutionary projects, they can't be in a place where there's nobody. They need to be in metropolitan places like Shanghai to cause further impact and damage to the chain, right? And so what you see is that, yes, Kang Youwei was exiled into Penang, right? But he had a terrible time there. He didn't really have any, he probably had a couple of newspapers, but he constantly wanted to come back, right? So here I think that there's a difference between political offenders and the common criminals who might have committed a one-time crime. All they want is to get away from the state. But somebody like Sun Yat-sen, they really wanted to go back to the heart of the empire, right? Yeah.
Thank you, Jenny, for the wonderful talk. I'm not a legal historian, so I have a question kind of following what John just asked. So for the list of all the treaties, as I understand the fugitives issues involved in the flow of the criminals for example, Russia, Japan, Korea, they have shared borders with those is a part of China. So that's easier for people to flow or to run back and forth.
Yes.
But from the list, we can see that most of the clauses pertaining to fugitive renditions, starting from the Opium Wars and starting from the England, United States, France, but Japan and Korea came out pretty late. So I'm just very curious why, because as I understand, if we study northeastern part of China, and we know that people travel back and forth, of course, including a lot of criminals or political crimes or other criminals. So why there the treaties between Japan, until so late?
I think, especially in Korea, and I think that prior to that, it was the tributary system, which is a concept that many people have attacked and discredited. But I think that you think of the tributary system as a system of law, right? So the Korean officials were actually collaborating actively with Qing bureaucrats because they themselves they really saw themselves as part of that legal empire, right? And so even though there were no formal treaties, they were exchanging fugitives depending on the severity of the crimes, right? For death offenders, then absolutely. So for some of these aggravated cases, they were actually instructed to kill on the spot. Right.
I see. So can we understand if we take the tributary system, there is the internal negotiation between handling these issues.
Yeah.
But right now we have Western powers.
That's right.
So that makes this issue. Okay.
I think that you see the disjuncture between the tributary way of thinking about things and this new Western way of thinking about fugitives, right?
Thank you.
Jesus articulated what I was trying to say a lot more clearly. You have a pre-existing system of empires. Then the empires actually bled into the surrounding areas as well. There is an extradition system of some sort before this arrangement. But then this assumes more of a configuration of states of equal footing that started emerging different points in time. So you have to renegotiate your system in a certain way. So I guess what I would love to learn more about is the pre-existing arrangement and how that informed this transformation to a new international landscape.
Yeah, that's a good one. So Jamie Kim Brown has a new book coming out on the pre-existing fugitive rendition between the Qing and some of these nearby states. Okay? Korea was one of them. Yeah.
Well, there might be a bit of an unfair question because I think that might go beyond what you cover in the book. But I wonder whether you can talk or give us at least a bit of an outlook of what happens in the Republican period. Because I'm particularly thinking, I know from other sort of legal fields, things like, the mixed court system and so on. Obviously, Chinese nationalism leads to much more of an assertiveness from the side of the Chinese of challenging what this kind of treaty system presents.
Yeah.
And challenging certain prerogatives of extraterritoriality. So
Yeah.
I wonder whether you could maybe talk a bit about how this sort of evolves.
It's a great question. This is something that I had to decide to, how much to research into, because my original plan was just to deal with the Qing, right? But then one of the things that we discovered is that in 1911, as the Qing collapsed, got lots of fugitives, right? And treaty ports became really important as the place of refuge of all of these Yuan Shikai's enemies, or people who Yuan Shikai sent to assassinate other people, and they became fugitive. I mean, the treaty ports then became really these zones of refuge, right? And for about 10 or 15 years, the Beiyang government trying to negotiate with many of these Western states to try to come up with a more comprehensive way of being able to arrest these political offenders from the treaty ports, right? And just as they were beginning to make headway to it, Chiang Kai-shek's Northern Expedition overthrew these warlords affiliated with the Beiyang government and established a new legal system based in Nanjing, right? And the mixed courts were abolished, where prior to 1927, the mixed courts, I think, is the place where many of these political cases were heard, and extradition cases were denied or granted. But the Nanjing government abolished the mixed courts. And all of these cases in treaty courts then get sent to the Jiangsu Gaodeng Fayuan, right? And then it gets to be ruled by Chinese judges, right? And so I think that by 1928, 1930 or so, it's no longer viable for, say, communists or opposition to the Republican government to claim treaty ports as a place of refuge. Some of them still did, right? But I think that legal space closed up in around the late 1920s. And so I think that's another significance for the abolition of the mixed courts, right? We usually think of 1943, the abolition of extraterritoriality, as a sort of the cutoff date of something significant that happened. I think of the end of the mixed courts is also important. Yeah, that's one. Yeah, but we could talk more about that. I mean, there's so much to learn as well. I mean, I'm still trying to see if, I could do another project on the Republican period, especially during the war. Fugitives then became something very different. Wartime emergency laws, right? Some of the POWs were also fugitives, right? Or these people who, but anyway, it probably would take another 5 or 10 years of research.
Let's forget. So yeah, if there are no other final questions, then what remains for me to do and all of us to do is thank Professor Day again for the wonderful talk. Thank you very much.